Good afternoon. We will call the case of People versus Monroe. This is a 15-minute mini argument on the application. You have a 2-minute free fire zone that you may waive, and you may also reserve time for rebuttal, but we ask that you do keep track of your own time.
Thank you. Good afternoon. May it please the court, Emma Lawton with Sato on behalf of Lashawn Monroe. Mr. Monroe's conviction for felony firearm is unconstitutional because the legislature did not intend felony firearm to be predicated on felon in possession. Mr. Monroe was convicted of possessing a handgun when he could not legally do so because of a prior felony. In 1976, that behavior could not support a charge of felony firearm. That was not a mistake. The legislature did not intend felony firearm to punish Mr. Monroe's behavior. And it communicated that intention by creating exceptions in the statute for people who violated firearm regulations. That included felons. That did not change in 1992. In 1992, the court's interpretation of felony firearm excluded all possessory offenses as a class from serving as predicate offenses. So when the legislature enacted felon in possession, the default was that as a possessory offense, it was not a predicate offense. The legislature did not need to amend felony firearm in order to make it an exception. And it is clear from the text and history of felony firearm that the legislature's intent was that felon in possession be an exception. The purpose of felon in possession was to simplify firearm regulations for felons. It was to put in one place the rules that governed which felons could possess firearms, how they could regain their rights, and what the penalty would be for a violation. And it is clear that the legislature intended judges to have discretion in sentencing for those types of penalties and enforcement. The legislature imposed a 5-year maximum sentence subject to the sentencing guidelines. There's no indication that the legislature also intended every person who committed felon in possession to be subject to a mandatory 2-year sentence under felony firearm. The legislature also communicated that intent in the legislative materials, which predicted that judges would not send an individual like Mr. Monroe to prison for mandatory prison because it characterized Mr. Monroe's offense as a nonviolent minor offense. Callaway upset the legislature's intent by reversing the legislature and by stating that felony firearm could be predicated on felon in possession. This court should overturn Callaway. The legislature has not authorized felony firearm as predicated on felon in possession, and by extension, it has not authorized multiple punishments where felony firearm and felon in possession are predicated on the same offense. I'll take the court's questions at any time. And I would like briefly to touch on the state of the law in 1992. People versus Walker had been decided in 1988. People versus Walker stated that possessory offenses were a class. That is a context that the court needs to take into consideration in determining what was the legislative intent. Why did the legislature not mention felony firearm in passing felon in possession? That's the context in which it's enacted. That creates an ambiguity. What was the legislature's intent? Additionally, as outlined in our brief, when it comes to felony firearm and the behavior that's being regulated, felon in possession is in the same ballpark as concealed carry of a weapon, as possessing a weapon, as obtaining a weapon without a license, which is a misdemeanor in 1976. All of this is dealing with the same general area of felon in possession. There's no indication that the 1992 legislature was doing anything else, anything other than simply enforcing the way that felon regulations would be done in a simple, cleaner way than had been done under the regime that existed in 1976, which involved, for purposes of notice, looking to a number of different statutes under the firearm regulations, under the Michigan Penal Code, determining what behavior had taken place and whether or not it violated any laws.
So I understand your argument, and I think it has a lot of intuitive sense of why this should be considered in the same class and it didn't exist. But what are we supposed to do with the fact that the statute is written to say that it applies except for 4 specific felonies? What are we supposed to do with the language of the statute that said, that doesn't include the charge here?
And
Even
there-
if it makes sense, I mean, I get, and how, and the timing of it, and why this would be, and it's the same category, and this is what, you know, in the general overall picture, we have statutory language that says an exhaustive list of 4 felonies.
So there are 2 points in time that have to be looked at. There's 1976, which obviously does not create an exception for felon in possession because that crime, as it is enumerated, does not exist at that point. But does create exceptions for the behavior that is animating felon in possession. And then in 1992, why didn't the 1992 legislature amend felony firearm? And the answer to that is People versus Walker. It's that the legislature did not necessarily need to create an exception in felony firearm because as felony firearm was being interpreted, a possessory offense was not a predicate offense. It's perhaps not as clean as we would like it, particularly since Walker was overturned by People versus Mitchell, but that happens in the future from the perspective of the 1992 legislature. And so that's why we have to look at the legislative materials and ask ourselves, what is the legislature doing? Why is the legislature enacting felon in possession, and what do they intend for it in the scheme of felony firearm? And it's clear from those materials that the legislature is not thinking about this as a predicate offense. The legislature is thinking about this as a fix to what had happened in 1990 with the firearms regulations and the fact that felons could no longer have their firearm rights restored. It's thinking about this in terms of a 5-year maximum sentence. It's thinking of this mainly in terms of someone who's going to be found possessing a weapon while they're committing a different crime. That's the area, that's the time when it thinks this is really going to come up. It sees Mr. Monroe as the minority in enforcement for felon in possession. So this is a crime that's being tacked on with other offenses. There's nothing there indicating that the legislature thinks that this is now going to become a predicate offense for felon in possession.
Okay.
If there are no further questions, I'll reserve my remaining time for rebuttal.
Thank you.
Good afternoon. Amanda Smith, Wayne County Prosecutor's Office. On behalf of the people of the state of Michigan, we are the plaintiff appellee in this matter. Defendant's application must be denied for 2 reasons. First, as defendant himself twice previously conceded, neither of the issues before the court today has been preserved for appellate review because he failed to raise this issue when the case was in the trial court. Defendant cannot meet his burden of demonstrating that clear and obvious error occurred when he pled guilty to felon in possession and felony firearm, as these dual convictions were expressly sanctioned by this court's opinion in Callaway. A defendant cannot prevail on an unpreserved claim of error if, in order to win, this court must overturn precedent and create a new rule. Second, this court has recognized that the fundamental principle of statutory construction is that a clear and unambiguous statute leaves no room for judicial construction or interpretation. The proper role of the court is simply to apply the terms of the statute to the circumstances in a particular case. In McIntyre, this court explained that the traditional principle of statutory construction forces courts to respect the constitutional role of the legislature as a policy-making branch of government, and it constrains the judiciary from encroaching on this dedicated sphere of constitutional responsibility. As you said in McIntyre, any other non-textual approach to statutory construction will necessarily invite judicial speculation regarding the probable but unstated intent of the legislature, with the likely consequence that a court will impermissibly substitute its own policy preferences. 40 years ago in Morton, this court said that the search for legislative intent of MCL 750-227B begins and ends in the plain language of the statute. And every iteration of this court, including Callaway, that has looked at the statute has said the same thing about it. Not only does it evidence a clear and unambiguous intent by the legislature to reach all but the accepted felonies, the list of excludable felonies is finite. Because felon in possession has not, never has been included on that list of excludable felonies, defendant's dual convictions are valid. For these reasons, the court should deny the application. I welcome your questions, and I will go in any direction the court is interested in talking about, or I'll just do my thing up here. One thing I would like to say is I don't think in my brief I cited to People versus Wilson, which is a 2017 opinion by Justice Larson. It was unanimous. That case is actually somewhat interesting. This court at that time looked at how the prosecutor is allowed to charge the felony firearm second and third offense notice. So how you calculate a defendant's prior convictions under the felony firearm statute if we want to aggravate it to felony firearm second or third. And Justice Larson in that opinion addressed, I think, the general tenor of the argument I hear coming from my friend on the other side, which is, and I'm going to quote from the opinion, defense has suggested many reasons why the legislature may have wanted to limit the increased penalties under 750-227B to convictions that arise out of separate incidences. Whatever the merit of those arguments, there's nothing in the text of the statute to suggest that the legislature agreed with them. And that's really what I think we have here. Going back 44 years, starting with Wayne County Prosecutor's Office versus Recorder's Court Judge, 1979, this court has looked at this felony firearm statute and said over and over again, it reflects an exceedingly clear intention by the Michigan legislature to punish every felony at which time a firearm is used, except for two exceptions originally when the statute was enacted, and then in the 1990s when the statute was amended to add two additional felonies. That list of exceptions has never been expanded beyond the four that are enumerated in the statute at this current time. I want to touch on, I think, one item with regard to my argument on plain error that I think is relatively important. Plain error reaches all issues in all cases, and all parties have obligations to raise errors as they arise in the trial court. And I think it's really worth thinking about the fact that this issue was not raised in the trial court, and this is a plea case. So even if this court is not really persuaded by the plain error issue and wants to really look at the merits of the issue under just a flat de novo preserved standard of review, what is the actual remedy we're talking about here? This is a plea to felony firearm, felon in possession. So unlike a trial conviction, on defendant's best day, what would happen is that the felony firearm conviction would be vacated, and the prosecutor would have the opportunity to basically go back and reassert the original charges in the case, which would be carrying concealed weapon and the habitual second offense notice. So the remedy that's described in the defense application, I just wanted to clarify because I didn't touch on it in my brief, is not for the court to vacate the felony firearm conviction. We actually would go back and unwind the plea, which is a little odd, but it's a plea case, so it's a little bit different.
And you would agree that if we agree with your position based on the statutory language, that the question that we teed up about whether or not People versus Ream was correctly decided isn't implicated?
Yes, that is definitely the people's argument, and I mean, this court in Wafer, which was I think just a term or two ago, didn't reach Ream because you said the statutory language is clear in the statutory manslaughter and the homicide statute. The language is clear. The legislature did not intend cumulative punishments. We never have to use the abstract element Ream-Blockberger test. And the same here. I mean, we are disagreeing about the clarity of the statutory language, but we are both firmly entrenched in our argument that the language is clear, enforce it as written. So Ream never comes into play. I will say that under Miller, I think a little bit suggests that it's like a hard line rule that you read the statute. If the statute's unclear, then you apply Blockberger. The U.S. Supreme Court is a little bit more free-flowing, like in Missouri versus Hunter, which is a very factually analogous case to the facts at issue here. You can apply the Blockberger test. You could just look at the statute. There's no order of operations. At the end of the day, the legislature rules the day, and their intent is going to control the outcome of the case. So even if a pair of convictions fail Blockberger, if the statutory language is otherwise clear that the legislature intended dual punishments, that's what's going to carry the day, even if Blockberger fails. That's Missouri versus Hunter. I don't see how Ream comes into play here. Ream is about compound offenses, felony, murder, and the predicate felony. That is completely different from what we have here, felon in possession and felony firearm, because of that additional statutory language that says you are guilty of felony firearm, and you get the additional sentencing consequences. It specifically addresses the cumulative punishment piece of the puzzle, which felony murder doesn't have any language to get into that issue at all. I truly don't want to just stand up here and hear myself talk. I truly don't, because that's not fun for anyone. I don't know if there are any particular areas that the court is interested in. I will just say this is not a new issue. When the felony firearm statute was passed in 1976, effective 1977, to no one's surprise, 2 years later, the constitutionality of that statute comes to this court in Wayne County Prosecutor versus Recorder's Court Judge. And it specifically was brought as a Fifth Amendment issue. And this court said multiple punishments are completely fine. That's what the legislature intended under the statute. The statute has been challenged pretty much every decade since it was enacted. And this court has always said the same thing about it. And I completely understand the argument from the other side, but as this court said in Wilson 2017, the language that they're arguing about, it just simply is not in the statute. And this court is just going to apply the statute as written, just as it has for the past 44 years. That's what the people are asking for in any event. Seeing no other questions, I'll take a seat. Thank you.
Thank you.
I'd like to briefly address preservation first. As our brief outlines, double jeopardy is a jurisdictional issue. And this court has recognized in New and in Carpentier that when there is a claim that goes to the heart of the court's ability to bring someone into court and convict them of a crime and sentence them, that is not an issue that requires preservation. That is an issue that prevents the court from exercising any sentence or any conviction for that defendant. It is void from the start, and no amount of preservation or lack of preservation can render that judgment void. And this court actually recognized that in People v. Miller, which was a multiple punishments double jeopardy case, in which the court stated did not apply any preservation requirements, despite the fact that the Court of Appeals had applied Carinas and had said this was a non-preserved error. I also want to talk again about context. The prosecution mentions People v. Wilson as evidence that this is an unambiguous statute and that this court has always imposed this unambiguously. People v. Wilson was overturning People v. Stewart, a case decided in 1992, which did find ambiguity in the statute and said the opposite of People v. Wilson. The court has to understand the historical context in which felon in possession was passed, which was a time at which the courts were finding ambiguities in the text of felony firearm. We disagree with that today, or the court has disagreed with that today, but that is the context in which felon in possession is being enacted. That's the context in which the legislature is making decisions about what to amend and what not to amend. So that is why there is ambiguity as to what the legislature intended. That is why it's important to look at the legislative history to determine what did the legislature actually intend. And that points to the legislature did not think that this was going to be a predicate offense. People v. Corey, which was decided, I believe, in 1991, is another example of this. Early 90s, finding ambiguity in the felony firearm statute. That was a case where a police officer was convicted of manslaughter and felony firearm predicated on the manslaughter. After his conviction, the legislature added language saying that felony firearm did not apply to on-duty officers. And the court, after that passage, said that intent was also present in 1976. despite the fact that there was nothing in the language that suggested that the court was clarifying an intent by the legislature. Recent precedents by this court have said that is not how felony firearm will be read. But that's the context in which felon in possession is being passed. That context is essential to understanding why there's no exception for felony firearm that was written in. And the statute has to be read in that context. This court has recognized repeatedly that the context, the historical context of the passage of a statute forms part of the plain reading of the text. That court noted that in People v. Wafer just recently. It also observed that in People v. Arnold, that context changes how we read the statute, and that means the court has to look to the legislative intent. And when you look to the legislative intent, there's simply no evidence that the legislature thought it was creating a new predicate offense for felony firearm.
Counsel, what do we do about the fact that the legislature's, amended the statute over time, and the ramifications from, the statute being interpreted as it is are well known, and the draconian effects. I mean, I don't think anybody's going to dispute the outcome. But they haven't fixed it. They haven't changed it. So I'm just wondering, does that affect our analysis on legislative intent?
I think there are two ways that the court can think about that. First is that the court has repeatedly said that legislative acquiescence is not a favored doctrine, that the legislature's failure to act on something is not evidence of legislative intent. And it observed in Dunishkowski versus Alpena Power Company that the legislature is not required to go through court opinions, spend amount of time figuring out what's right and what's wrong, and then, as the opinion put it, put out forest fires. There was an amendment in 2015. The amendment in 2015 did not relate to the language that's at issue here about firearms. It was adding a new provision for pneumatic guns. Pneumatic guns aren't firearms. They have different requirements. They're going to have different exceptions. So the legislature's failure to amend the felony firearm provision, again, is not evidence of legislative intent because the legislature is in a different portion of the statute. That has been played out in this court, a similar analysis in People versus McKinley, for example, which between the decision in People versus Gahan about the restitution statute and People versus McKinley, there were 5 amendments to the restitution statute. Every time the legislature amended the statute, it did not change the language that was being interpreted in People versus Gahan. And so this court, in deciding People versus McKinley, simply went back and asked, what did the legislature intend, without asking, should the legislature have changed this later on? And if there are no further questions.
Can you just touch on the remedy piece that Sister Counsel raised and what's being asked for here as far as that we can't just vacate the one, that we would have to send it back, and what impact that would have?
Well, for Mr. Monroe, he was sentenced to 2 years in prison. He has served those 2 years. He's been released. His guidelines at the time were 5 to 23 months. So he's served slightly longer than he would have served if he had received a top of the guideline sentence. So from a practical perspective, vacating his conviction for felony firearm does not really change anything about the sentence that he serves. It's our position at this point, he has served the sentence that was imposed by the court. He has been released from any conditions of the court. And the judgment for felony firearm is void because it is not a crime that he could be convicted of and should not have been charged with. And so we are asking this court to vacate that.
Okay, thank you.
Thank you.
Any other questions? Nope. Okay, thank you both. The case will be submitted.